Good day, sir. We are from Tutorial 9 Group 4. This is our group presentation for the subject Public International Law, and we will discuss from Australia's perspective. Before we begin, we will play a short introductory video related to this question.
Breaking news. The newly appointed Minister of Investment, Trade and Industry today stated that the reciprocal trade agreement with the United States of America is not a point of no return and that unfair terms may still be renegotiated. Here's a leaked footage of the minister and his advisor.
Advisor A, can we still protect our sovereignty?
Well, Mr. Wong, only if international law allows it and only if you use the right legal mechanisms. The real question isn't whether sovereignty has been lost, but whether it can be constrained, legally reclaimed, or safeguarded after consent.
Good morning to our lecturer. Today I will explain how the principle of sovereignty and non-intervention shape state relations in international law and how the modern treaty obligations and external influence can limit state sovereignty. First, state sovereignty means that a state has supreme authority over its own territories and internal affairs, while sovereign equality means all states are legally equal regardless of the size or power. The principles of non-intervention support this by prohibiting the state from interfering in the domestic affairs of other states. Together, this principle protects state independence and form the foundations of international law. However, in the modern international relationship, sovereignty is no longer absolute. States often voluntarily accept limits on their freedom by entering into international agreement. A good example is Australia's membership in the World Trade Organizations, or also known as WTO. By joining the WTO, the Australia agreed to follow binding trade rules and accept external dispute settlement. While Australia remains the sovereign, it cannot freely impose trade restrictions that breach the WTO obligations. This shows that the treaty obligation can legally constrain the state actions. Secondly, sovereignty can also be affected by the external influence, especially where there is an unequal bargaining power. An example is the Australia and the United States Free Trade Agreement. Although the Australia consent to the agreement, certain provisions limit the Australia regulatory freedom, particularly in the areas such as the intellectual property and the public policy. This demonstrates even without the direct interventions, stronger states like the Americans can influence the treaty outcomes, indirectly weaken the sovereignty of the Australia. In short, sovereignty and non-intervention is still shape the state relations. But modern treaties and external pressure show that the sovereignty today is conditioned and flexible. International agreements do not remove the sovereignty, but they can redefine its scope in increasing interconnected the world. That's all my presentation today. I will pass it to the next person.
Greetings, sir. My name is Henry Wong, and I'll be presenting the second issue. Notably, this issue has two main parts which I will discuss accordingly. First, how is treaty law applied in Australia? To understand this, we must note that Australia follows a dualist legal system, unlike a monist system where treaties automatically become domestic law. In Australia, a treaty only has legal effect on citizens and domestic rights if it is transformed into law through an act of parliament. Now, there are two ways treaty law are applied, which are by rectification and statutory interpretation. First, through rectification, Australia is a party to the Vienna Convention on the Law of Treaties, also known as VCLT. Under Article 14, a state expresses its consent to be bound by a treaty through rectification. Consequently, the principle of pacta sunt servanda under Article 26 applies, which means that every treaty in force is binding on the parties and must be performed in good faith. Second, treaty law may be applied through statutory interpretation. When Australian statute is ambiguous, courts will interpret it in a way that is consistent with Australia's international obligations. However, international law itself cannot override domestic legislation. This was shown in Polite and Commonwealth case where Greek nationals challenged regulations requiring them to serve in the Australian military during World War II. Although international law was raised, the court held that it could not invalidate a domestic statute, reinforcing parliamentary sovereignty over international obligations. Having explained how treaty law is applied, I now turn to the second limb of the question: how treaty law is used as a mechanism of future control to protect Australian sovereignty. Now, there are two key ways treaty law can be used to protect sovereignty. First, through termination and withdrawal clauses. Under Articles 54 and 56 of the VCLT, Australia may withdraw from treaties or choose not to adopt optional protocols that no longer serve its national interests. Second, through reservation, which allows a state to exclude or modify the legal effect of certain treaty provisions. Australia has used this mechanism before in 1980 when rectifying the ICCPR. Through reservation, Australia reserves the right not to introduce further legislation as existing domestic laws were considered sufficient. In conclusion, although treaty law guides Australia's international obligations, it does not override domestic law. Through its dualist system, parliamentary oversight and control mechanisms such as withdrawal clauses and reservations, Australia is able to engage internationally while safeguarding its sovereignty.
Thank you to the previous presenter. My name is Eng Jun and I'll be presenting on question 3, which is how international law addresses state responsibility and peaceful dispute resolution settlements when a state perceives excessive external control, considering pathways for accountability and mechanisms for resolving conflicts while balancing sovereignty with compliance to international obligations. The core argument regarding international agreements is that while they are binding, they do not grant external powers with unlimited authority. The legal foundation for accountability is found in the Articles on Responsibility of States for Internationally Wrongful Acts, also known as RCEPA. If the terms of the reciprocal trade agreements are used to infringe upon Australia's domestic jurisdiction, these actions may be framed as internationally wrongful acts. Specifically, if the United States of America violates fair and equitable treatment, also known as FET standards, Australia has clear grounds to seek accountability under international law. To resolve conflicts while balancing sovereignty with compliance, Australia utilizes an escalation ladder for peaceful dispute resolution. The structured approach is aligned with the UN Charter Article 2 Sub 3 and Article 33. Negotiation is primary, low cost stage where the parties attempt to identify and negotiate unfair terms directly, and next, should negotiation fail, a neutral third party is introduced to facilitate a resolution by way of mediation, and arbitration serves as a final resort for binding legal resolutions when diplomatic pathways are exhausted. Furthermore, when external control becomes coercive or threatens vital national interests, international law provides legal armor according to Chapter 5 of RCEPA. Australia may legally withhold certain treaty obligations as a proportionate response to a breach of any other state. And Article 49 allows Australia to implement countermeasures such as temporary suspension of reciprocal tariff benefits, and Article 25 allows for defense actions to be taken to safeguard vital interests of the state against grave and imminent peril. In summary, international law provides a robust mechanism for states to defend their sovereignty against excessive external control. By utilizing the escalation ladder and the principle of states' responsibility, Australia ensures that it remains a party to the rule of law while protecting its domestic autonomy. Thank you. That's all from me. I'll be passing it to the next presenter.
Good evening, sir. I'm Evan Chai, and I will present on question 4 on how domestic constitutional frameworks for treaty making and implementation interact with international obligations. I'll be focusing on the balance between the executive and the legislative roles, judicial interpretation, and mechanisms such as the reservation of termination clauses to safeguard the sovereignty. The separation of powers in Australia are separated into three, which is the judiciary, legislation, and the executive. In the Australian Constitution, it states that in Section 61, it vests the executive powers of Commonwealth in the King, accessible by the Governor General, which means that the executive have the powers to make decisions based on the policy. And Section 51, Clause 29 states that the Parliament's legislative power in the external matters. And now let's move on to the Australia's treaty making process, which is the first step is the negotiation, which is done by the executive, and the finalization of text also done by the executive branch. And the executive council will approve the treaties and the minister will sign. And the most important part is the scrutiny by the parliament. And lastly, it will enter into the force. Since it has to be scrutinized by the parliament, so under the Australian dualist system, the treaties have no domestic legal effect unless it was implemented by the parliament. So the parliament acts as a constitutional gatekeeper, which preserve the legislative sovereignty, and this creates a balance between the executive and the legislature, which the executive is the international commitment and the legislature is a domestic legal authority. Lastly, the judicial interpretation and constitutional limits, which in the Tasmanian Dam case, the court confirmed that the parliament may legislate to implement the treaties, and the legislation made must reasonably capable of being considered appropriate and adapted to fulfill the treaty obligation, which means that the termination and reservation clauses can be made by the parliament as a sovereignty safeguards. So in conclusion, the Australia's dualist constitutional system operates as a final safeguard for the national sovereignty, as it acts like a double checking system to ensure that the executive does not misuse the power. Thank you.
Good morning, Mr. Justin. I'm Xavier. Now I'll be presenting question 5 on proposing an actionable policy. So following the signing of the reciprocal trade agreement between Australia and America, it raises a core legal issue. Can international trade agreements erode state sovereignty? So we know that in law, sovereignty refers to a state authorities to control its own economic, political, and regulatory decisions. For the next slide, under legal framework, under international law, treaties do not remove sovereignty, they limit it by consent. For example, in the Lotus case 1927, where the court held that a state is free to act unless prohibited by international law. And according to Article 26, however, once a treaty is signed, Article 26 and 27 of the VCLT states that it requires good faith performance and domestic law cannot justify non-compliance. Thus, Australia cannot simply ignore the RTA once it enters into force. How RTAs can erode sovereignty. Although legal sovereignty remains, economic and regulatory sovereignty may be constrained. First, trade agreements may pressure states aligned with foreign policies. In Nicaragua against United States, the ICJ affirmed that states must not intervene in the internal or external affairs of others. And secondly, investor protection clauses can chill public interest regulation. In Philip Morris against Australia, the tribunal dismissed the claim as an abuse of process, reinforcing that legitimate public health laws should not be undermined by the ISDS. For the next slide on protecting Australia's sovereignty, international law provides safeguards. First, drafting protections such as public interest exceptions, GATT Article 20 states, preserve regulatory space for health, environment, and security. Second, interpretative statements, Article 31 of the VCLT can clarify that the RTA does not require alignment with America's foreign policy or sanctions. Third, review sunset and termination clauses, Article 54 of VCLT allows renegotiation or withdrawal when necessary. And for avoiding treaty conflict and market risk, Australia should adopt robust compliance systems, parliamentary oversight, and impact assessments. Article 62 of the VCLT allows revision for fundamental change. Example can be seen in the Chigovo-Nagamomo's case. In conclusion, international trade agreements does not destroy sovereignty, but they can constrain how it is exercised. Thank you, Mr. Justin, for listening. This is the end of our presentation.